Binns and Dr. Brown Burke. We are also joined online by Senator Sinclair. You're there, Senator Sinclair. Senator Shireen Golden Campbell. Also, I think Minister Favour Williams has intimated she's now on. And I think Member Carenza Morrison. And I think...
Good morning, Chair.
Hi, good morning, Carenza. And I think Mr. Donovan Williams will be joining us shortly. So I want to welcome...
Morning, Mr. Chair. I've joined.
Yes, wonderful, Member Williams. So we do have a quorum. And the two main items today really will simply be to approve the minutes of our last meeting and also to look at the report and to approve them. I should also mention that we do have online several members of the technical team. I think SG Marlene Aldred and Mr. Paul Bailey from MOJ. Who else is online? I think quite a number of other members. The parliamentary interns are online along from OPC 2. So we want to welcome everyone to this hybrid meeting, which we're hoping will just be to take care of the minutes and also the joint select report. Now, I had a look at the minutes. I did not see more than, I think, one or two slight corrections. Right here, this is, what page is this? The chairman reminded instead of a reminder. Senator Charles Sinclair, you're on. Yes, reminded instead of reminder. Well, on page 9, right. On page 9, just a slight grammatical spelling, really. The second paragraph, the chairman, instead of reminder, reminded members that an adult who committed non-capital murder would be sentenced to life or a 30-year minimum sentence. Are there any other corrections noted by members to the minutes?
Good morning.
Hi, morning, Charles. Please go ahead.
On page 9, I don't know if you dealt with it because I reminded the paragraph above that. You have a line which is 1, 2, 3, 4. The 9th line was the expectation that a child aged 14 and 17 should that be between, not ages 14 and 17, because then you would have missed out 15.
It should be a child age between 14 and 17.
To 17. Yes, sir.
Yeah, it should be here. Age 14. If it was the expectation that a child age 14 should be aged between 14 and 17 years would be different from when he or she entered the correctional system after serving a number of years. Okay, thanks. So, between. Charles, you're okay with the minutes then? Any corrections from any other member?
Just one other quick, I don't know, Minister, on page 8, if I read it correctly, in the second paragraph, the 10th line in the second paragraph.
Okay.
Where it says it would be a life sentence or a maximum of 30 years. Maximum. Is maximum the correct or minimum?
Should be minimum. In the second paragraph, he reminded the committee that the sentence for capital murder for adult was sentence of death or life, and if a life sentence was imposed, it would be either without parole or a minimum of 50 years. He explained that for non-capital murder, it would be life sentence or a maximum, no, it wasn't 30 years. I think we are going 45 years. Isn't that my recollection? For non-capital murder, the sentence would be a maximum of 45 years. CPC, isn't that my recollection? For non-capital murder, the maximum would be 45, either life sentence. He said if a life sentence was imposed, the minimum number of years to serve would be 30 years, and the determinate term to be served would be 20 years. Is it 30? 30? Apparently, Charles, that is correct, says either if it was non-capital, then it could be life sentence or a sentence of 30 years, but they would serve. You sure that's correct? This is for the adults? I would say rather than not a maximum, a minimum of 30 years. It's not a maximum, a minimum of 30 years. So the sentence would be anything in excess of 30 years. Isn't that so, CPC? It's a minimum, Charles. So it's not maximum. It's a minimum. So on the 8th page, 10th line, or a minimum. So the judge could sentence a life sentence, but if the judge intended to impose a determinate sentence, it cannot be less than 30 years. And in terms of the, let me just emphasize for the adults again, my recollection of the agreement, understanding, and members can correct me if I'm wrong. For capital murder, it's either death or life imprisonment. If it is life imprisonment, then it can be life without parole, or it can be life with a minimum of 50 years before parole. That's for capital murder. For non-capital murder, it can be life sentence or a determinate sentence not less than 30 years. If life sentence is imposed, then they must serve at least 30 years before parole. And if it is a determinate sentence, whatever determinate sentence is, it could be 40, 50, but not less than 30 years, they must serve at least 20 years before parole. So that's my understanding that we are going to recommend. And I think, to the best of my knowledge, there was a consensus on the sentencing of the adult convicts. Where we had some majority was in relation to children, and we'll get to that later. So that basically is the minutes. So Charles, I ask that you approve, you move for the
I so move, Mr. Chairman.
Thank you very much, Senator Charles Sinclair. Seconded by?
MP Morrison.
MP Morrison. Thanks very much, MP Carrington Morrison. We now have a look at the report, and what should be noted is that the report having been circulated, there were some corrections, and I think the the Secretary highlighted the corrections that were made. I have read it through, and one point to note on page 10, you should have page 10, the end of the second paragraph, where you said, who is convicted of capital, you left out of murder. Capital, the 10th. Just the bill short entitled, the Child Care and Protection Act. Go next page, Capital. It's the paragraph that says the bill short entitled the Child Care and Protection Amendment Act 2023. And at the end of the paragraph, the second line to the bottom, where it read, who is convicted of capital murder. The word murder was not included, so include the word murder. Are there any points to note, members? Or I see the EG Chambers and the technical team had gone through the report, and in red are some of the recommended changes to the second draft. So the initial draft that was before us last time, the technical team had gone through and made quite a number of corrections, and I would like to thank the technical team, especially from the Attorney General's chambers, that indicated a number of corrections to the original draft. So before you, you will see in the report itself, especially on pages 9, 10, and 11, a number of italized in red corrections. So if you had read the first report, kind of look at the corrections recommended by the technical team and see if there's anything there. At the page 10, colleagues, where it says the bill short entitled the Child Care and Protection Amendment Act 2023, the first line reads, we noted that the provisions of the bill did not apply to children under 14 years, but children over 14 years. I think it's fair to say the provisions in relation to murder. To be specific, we note that the provisions of the bill in relation to murder, did not apply. Because under 14, the act applies where the maximum penalty that the judge can impose is 25 years. Isn't that so, CPC?
It did not apply to murder, which attracted the death penalty.
Right.
That was it.
Right. So because, because with respect to children, death does not apply. Okay? But you see, so I think it's in relation, we could say the provision of the bill in relation to capital murder. Should we put it that way?
Capital murder, so.
Just a murder.
Murder which attracts the death penalty.
Okay, we're just a murder. Out of an abundance of caution, I'm going to read the specific findings. Senator Golden, would you like to say something? Senator Golden, you're not coming across. You could try again. I don't have to press anything here. She could. Go ahead, Senator Golden. We're not hearing the Senator Golden, but if you can, if possible, you could join us when you're ready. All right, I'm going to read the last 2 pages where a number of corrections were made, but also finalize what the committee basically decided. Sure. That's page 910. I will start at page 9. Yes. Okay. So I'm going to start at specific findings. The bill short entitled The Offences Against a Person, Amendment Act 2023. Members of your committee were advised that the circumstances that give rise to capital murder were found in sections 2, subsection 1A to F, section 21, subsection 1A, and section 3, 1A of the Offences Against a Person Act. We noted that the possible sentence for capital murder is either sentenced to death or to imprisonment for life, and a judge can grant a life sentence without parole. Your committee noted that the current life sentence for capital murder is a period not less than 20 years before becoming eligible for parole, and the proposal was to increase the same to a minimum of 50 years. We support the proposal since capital murder is the most egregious type of murder, and the sentence for same should reflect the seriousness of the offense. We took note of the fact that the current penalty for non-capital murder is imprisonment for life or a term not being less than 15 years, and there were a range of circumstances in which non-capital murder was committed, such as in domestic situations. It was revealed that mitigating circumstances such as diminished responsibility or provocation could be factors considered to lessen the charge of murder to manslaughter. We note that an accused person had to serve 15 years before becoming eligible for parole if a life sentence was imposed. It was revealed that if a fixed term of not less than 15 years imprisonment was imposed, the accused was required to serve at least 10 years before becoming eligible for parole. The bill proposes that, with respect to non-capital murder, a life sentence should be increased from a minimum of 15 years to a minimum of 40 years imprisonment before becoming eligible for parole, with the alternative fixed-term sentence of imprisonment increasing from a minimum of 15 years to a period being not less than 45 years, with the accused being required to serve at least 35 years before becoming eligible for parole. The majority of the committee agreed that the alternative fixed-term sentence of imprisonment should be increased from a minimum of 15 years to a period not being less than 30 years, with the accused being required to serve at least 20 years before becoming eligible for parole. After extensive discussion on the matter, we recommend that no changes necessary for the proposed amendments to Section 3(1)(c)(a) and Section 3(1)(c)(bi) of the Principal Act as reflected in the bill. We, however, recommend that the following amendments be considered in relation to Section 3 of the Principal Act, that is, A, in subsection 1b, delete the word 15 and substitute therefore the word 30, and in section 1cb2, delete the word 10 and substitute therefore the word 20. Is that correct, CPC? That's what was agreed, right? And that's what we're putting. Okay, the bill short entitled the Criminal Justice Administration Amendment Act 2023 Considering that your committee recommends that in pursuant to Section 3(1)(b) of the Offences Against a Person Act, the court shall impose a sentence of imprisonment for life or such other terms as it considers appropriate, but not less than 30 years for non-capital murder, we are of the view that Section 42(e)(3) of the Principal Act, which provides for the prescribed minimum penalty, should remain unchanged. We therefore recommend that Clause 2 of the bill should be deleted and Clause 3 be renumbered accordingly. I think that's correct. Now, the bill shortly entitled the Child Care and Protection Amendment Act 2023. We noted that the provisions of the bill did not apply to children under 14 years. We noted that the provisions of the bill in relation to murder did not apply to children under 14 years, but children over 14 years. Your committee agreed that Section 78(5) of the Principal Act, which provides that a child who is under 14 years who commits murder should not be sentenced for a period exceeding 25 years, should remain unchanged. So that applies generally to children under 14. Members of your committee were, however, divided regarding the proposed number of years that should be recommended for children aged 14 to 17 years who commit capital and non-capital murder. So members, listen carefully, and if there are any changes, please let us know. For capital murder, 4 members of your committee agreed that a child 14 to 17 years should be sentenced to imprisonment for life to a term of not less than 50 years and not being eligible for parole before 20 years. This should be for imprisonment for life or to a term of not less than 50 years. Or to a term of not less than 50 years. Otherwise, it wouldn't make sense. So it would say 14 to 17 years should be sentenced to imprisonment for life or to a term of not less than 50 years and not being eligible for parole before 20 years. So they could get 50 years, but they must serve 20 years before they're eligible for parole. One member proposed that a child should be liable to be sentenced to a term of not less than 50 years and not being eligible for parole before 30 years. 2 members of your committee were undecided regarding the minimum number of years to be proposed for the sentencing of children who commit capital murder. It was recommended that the bill should be amended to reflect the changes proposed by the majority of members at the meeting. That is, a child between the ages of 14 to 17 years who is convicted of capital murder should be liable to be sentenced to imprisonment for life, and this should, or to a term of not less than 15 years, and not being eligible for parole before 20 years. It should be, or to a term of not less than 50 years. It was in the same language earlier. Quiet. For conviction in relation to non-capital murder, SG, you're on.
Yes, thank you. Thank you, Chairman. I have 2 points to raise. One, it may not be, I'll leave it to you and your members to decide. In that same paragraph we're looking at, but starting from page 9, we start speaking about murder, and then later on we start speaking about capital and non-capital murder. I was wondering if all along in that paragraph we should have spoken about capital and non-capital murder, just so that nobody tries to pick it apart later at some other stage. So it's just for clarification. My other point...
No, just a second. You're talking in relation to children, right?
Yes. So at the last paragraph on page 9, remember, we're just dealing with that paragraph. Starts on page 9, goes on to page 10. Mm-hmm. So the last paragraph, it starts by saying, we noted that the provisions of the bill, and then you said we would insert in relation to murder. Don't have a problem with that. It's just that later on we start speaking about non-capital and capital murder. So I'm wondering, just so that there is no need for any further explanation at some later stage, that we just say in relation to non-capital and capital murder, or capital and non-capital murder. however the formulation is,
I think
rather than just saying murder.
I must tell you, CPC had asked CPC, and CPC in relation to children, especially in relation to like the death penalty, I think CPC,
Well, yes, and in the
she said
sense
just
that-
use the term murder. No, go ahead.
And I get that, I get that. And it says murder in the first and the third line.
Yes.
But then later, by the sixth line, we start speaking about non-capital and capital because the committee kept making distinctions.
Sure.
So I am just suggesting that since we have had to keep breaking out and making it clear about non-capital and capital, I was just thinking that maybe we should do that from the beginning because I can see that someone can raise it as
Yeah.
an issue.
All right.
Although we should all be using the
So
same rule.
guide
of
us here
interpretation.
then, SG. So we noted that the provisions of the bill
In relation to capital and non-capital
in
murder.
relation to capital and non-capital murder. So we're going to, is that okay? Go ahead.
John, so the
And then
first sentence, that would only apply to capital murder. We noted that provisions of the bill did not apply to children under 14.
Sorry, yes,
provisions
sorry,
of the
to
bill.
capital murder.
Yeah.
All right, so-
in
Yes,
relation
sorry,
to capital
sorry about
murder did not apply to
All
children.
right, so in
under
relation
14.
to the first line, we noted that the provisions of the bill did not apply, if provisions of the bill in relation to capital murder, agree? Did not apply to children, okay. Which provides, and then members of your committee,
Sorry, so in the third line, third line, your committee agreed that section 78(5) of the Principal Act, which provides that a child who is under 14 years who commit
is that,
murder
should it be
sentenced to
capital and
life.
or non-capital murder? So we're going to say capital or non-capital murder. Capital
Well,
or
and-
non-capital murder. Capital or non-capital murder. And so those were the two.
No, I had something else. So I classified those as one issue. The second is really on the top of page 10, where we speak about the parole, not being eligible to parole before 20 years.
Yes.
I think it's more precise to say not being eligible to parole before serving. Is it? And it's before,
Okay, before serving 20 years.
yeah.
Right, so what is being proposed in both lines, not being eligible for parole before
And it's in
serving.
the last line of
In
that
both
same
sections,
paragraph in,
before
on
serving
page
20
10.
years, yes. So it's about the 10th line and the last line of that paragraph.
At the last line. Thank you. That's it. Very
Wonderful.
minor.
Thank you, SG. All right, so to continue, for conviction in relation to non-capital murder, it is recommended that a child shall be liable to be sentenced to imprisonment for life or such other term not less than 30 years, but serving not less than 15 years before becoming eligible for parole. 5 members of your committee suggested that a child should serve a period of not less than 15 years before becoming eligible for parole. However, the 5 members, 1 member suggested that the determinate life sentence that should be served by a child should be 25 years, whereas the other 4 members suggested that the determinate life sentence that should be served should be 30 years. 2 members of your committee suggested that the child should serve a period of not less than 10 years before becoming eligible for parole and did not recommend a determinate life sentence that should be served. It was recommended that the provisions of the bill be amended to reflect the recommendation of majority of members at the meeting. That is, the court may specify a period of not less than 15 years that a child should serve before becoming eligible for parole, and that the determinate life sentence that should be served should be 30 years. The Attorney General's Chambers advises us of a discrepancy regarding the provisions that were examined by the committee in relation to the sentencing of children under Section 78(4) of the Child Care and Protection Act, which provides that a child shall not be sentenced to imprisonment with or without hard labor for any offense. Rather, it was noted that the terminology of sentencing to be detained is used in the Child Care and Protection Act. We recommend that the appropriate minister undertake research to address the anomaly. I can assure you, SG, that I've asked Mr. Bailey to look at that and see how we can do whatever modification to that particular provision, the term to be detained is now outdated. Am I not right, CPC? It's one that was used when we had where a child commits murder or for whatever, and they're detained at the Governor General's pleasure or the court's pleasure. Isn't that so, CPC? That's my recollection.
Right. So when the Child Care and Protection Act had come into force, it had changed the terminology from being sentenced in prison to being detained in a juvenile correctional facility. So that, for consistency, should be reflected in other pieces of legislation.
So it should be, so to be detained should be changed to be imprisoned.
No, the other way around. Imprisoned, where it speaks about imprisonment, it should be changed to being detained.
And this is for children under 14?
Yes.
Okay.
But Chair, just to go back to what you had read on page 10 in the last paragraph, that also the qualification when it refers to a child, it should be to a child who has attained the age of 14 years. Because that was the category to which those...
No, tell us the line, please.
Yes. So it says, for a conviction in relation to non-capital murder, it is recommended that a child who has attained the age of 14 years, instead of just referring to a child, in the first sentence of the last paragraph.
How it is written, this could also refer to the child before reaching the age of 14, and we're specifically talking between those who are 14 to 17 in this category.
Correct.
So it's just a question of making the distinction for clarity.
Wonderful. Thank you very much. So that really is the... Sorry. No. Yeah. So if there are no other changes, I'm going to assume, or no other objection, that this will be the report which we are going to ask members to sign. Yes, CPC.
Chairs, in relation to the list of amendments, there's this square bracketed item on page 3, which relates to the offenses that, other than murder,
Right.
that attract the death penalty.
Right. So I'm just going to ask members if they get the chance to look now at the bill and in relation to the amendments to the Offense Against a Person Act, the clause 2, remember clause 2 was deleted and clause 3 now become clause 2. Okay? So clause 3 now is renumbered clause 2. And in that clause 2, in paragraph A, delete the word 45 and substitute therefore the word 30. So this is offenses against a person bill. The offense against a person bill, you have it. No. We're looking first at the offense against a person bill recommended by the... So remember, we have deleted clause 2. So clause 3 now become clause 2. And in clause 2A, you have the bill there, the bill itself. We're going to remove the word 45 and substitute therefore the word 30. And in paragraph D, delete the word 35 and substitute therefore the word 20. Agreed? So that's the Offenses Against the Person Act. All right. So we have that. Now, I just would like members, colleagues, to follow me now in relation to the amendments to the Child Care and Protection Amendment Bill. And this is to reflect, I think members will note that what I'm about to read, it should be with you on your, but for comprehensive noting, I will read what was agreed and will be presented as a part of the report to be presented to Parliament. So in the long title, we are going to add next after the words "an act" to the word "further." And in clause 1, insert next after the word "amendment" the words "number 2." So it's amendment number 2. Clause 2, delete the clause and substitute therefore the following. This is now clause 2. Section 78 of the Principal Act is repealed and the following substituted therefore. Restriction and punishment, section 78(1). Except as provided in this section, a child shall not be A, imprisoned, sentenced to imprisonment with or without hard labor for any offense, or B, committed to an adult correctional center in default of payment of any fine, damages, or costs. 2, sentence of death shall not be pronounced or recorded against A, a child convicted of an offense, or B, any other person convicted of an offense, if it appears to the court that at the time when the offense was committed, the person was under the age of 18 years. 3, in any case where a sentence of death could have, but for subsection 2, been imposed, then notwithstanding the Parole Act and section 3 of the Offenses Against a Person Act, A, if the offense is murder, and Roman 1, the offender is a person referred to in subsection 2B, capital A, the offender shall be liable to be sentenced to imprisonment for life or for such other term of not less than 50 years as the court considers appropriate. And B, on sentencing the offender, the court may specify a period of not less than 20 years. I think that was agreed. So remove the bracket, 20 years, which the offender should serve before becoming eligible for parole. Roman 2, the offender is under the age of 14 years. The offender shall, subject to subsection 4, be dealt with in any manner provided by section 76. Or Roman 3, the offender is the child who has attained the age of 14 years. Capital A, the offender shall be liable to be sentenced to imprisonment for life or such other term of not less than 50 years as the court considers appropriate. And capital B, on sentencing the offender, the court may specify a period of not less than 20 years. That was agreed, which the offender should serve before becoming eligible for parole. Now, this is important, members. We need something here now, some direction and agreement. If the offense is an offense other than murder, although it doesn't concern this committee, the consequential effect of concentrating on murder, we have to see what the sentence should be, if any at all, in the Child Care and Protection Act. If the offense is an offense other than murder, the offender shall be liable to be sentenced to imprisonment for life, or, and that's a fixed term, and we can put similar to, we can put 20 years, and the court on sentencing the offender may specify a period which the offender shall serve before becoming eligible for parole. I would say, colleagues, that in relation to other offenses, we could put, shall be liable to be sentenced to imprisonment for life or a fixed term not exceeding 25 years. A fixed term not exceeding 25 years. And a person so sentenced shall be liable to be detained in such place, including an adult correctional center, if the person has attained the age of 14 years, on such condition as the minister may direct, and while so detained shall be deemed to be in legal custody. So that particular section is in relation to children under 14. To 17, who are non.
Other than murder.
For offenses other than murder.
Right, where the child is has attained the age of 14.
Okay,
yes.
okay, okay. So that particular section where we are specifying imprisonment for life, it could be robbery, it could be gun crime, it could be any serious offense.
Like to ask, Chair, is that this 25 that you are proposing, is it aligned with any other
Yes.
legislation in relation to the similar type offenses? In other words, if we are using 25 years, can we use the same period that would be associated with another legislation prescribing these offenses?
The reason I use 25, and maybe we should think about it, colleagues, for children under 14, it was 25.
Oh,
So the question, remember the person could be sentenced to life.
yes, in the first instance.
But if you want to give a fixed term, maybe 25 is low, we should put 40. Because for under 14, it is 25. We're talking about the maximum, not the minimum. And once in other words, if you say 40, the court could still sentence 25. But if you put 25, the court can sentence 30.
All right, you just made the clarity for me that we're speaking about the maximum and not the minimum.
And not the minimum. And that is why I would say in this case we put 40 because it's a maximum. Or to imprisonment for life or a term not exceeding 40 years. And then you see it gives the court a greater latitude for much lesser sentence, and in fact we are not going to determine the period before they can be granted parole. The court can say 5, 10, because this is for non-capital, an offense other than murder. All right, and a fixed term not exceeding 40 years. This is just for consistency in the Child Care and Protection Act. Yes, no problem. 4, where a child who is under the age of 14 years commits an offense specified in the 4th schedule, and the court is of opinion that none of the other methods in which the case may legally be dealt with is suitable, the court may sentence the child to be detained for such period not exceeding 25 years. This is under 14, as the court may determine, and B, the child during that period be liable to be detained in such place, including an adult correctional center, and under such conditions that the minister may direct, and while so detained shall be deemed to be in legal custody. 5, notwithstanding Section 3 of the Offences Against a Person Act, where a child was attained the age of 14 years is convicted of the offense of murder falling within Section 2.2 of that act, the child shall be liable to be sentenced to imprisonment for life or for such other term of not less than 30 years as the court considers appropriate. And B, on sentencing the child, the court may specify a period of not less than 15 years, that's the majority position, remove the bracket, years which a child should serve before becoming eligible for parole. And the child shall during that period be liable to be detained in such place, including an adult correctional center, under such conditions as the minister may direct, and while so detained shall be deemed to be in legal custody. CPC, thanks. I think this reflects, what we have decided. And so basically, they will be included as a part of the report. Members, we have reached a stage where, I think we have done a fantastic job.
Minister.
What I would do now is for motion to, the report itself, which include that. Just for completion, what we just did for capital offenses other than murder. Why do we call them capital offenses? That's for offenses? All right.
Yeah.
All right, for capital offenses other than murder, a child 14 years and over shall be liable to be sentenced to imprisonment for life or a fixed term not exceeding 40 years. Okay? So we ask for an approval for that. Is that okay, colleagues?
Yes, Minister.
as one of the recommendations in the report. Could I also ask for an approval of the report so that it can be signed and by members and then to be tabled in the House as the earliest possible time? Yes,
I so move, sir.
Senator Kevin Gale and Member Carenza Morrison and other members have no objection. That's okay, Carenza?
Yes, Minister. I only have one question, just seeking clarity.
Sure.
On the matter of coercion of a child, how are we treating with that?
Truth of the matter is that we really felt that it's a matter that could be dealt with by the DPP to the extent that if the coercion is one which makes the parent or the adult, even that the child is like an agent and the adult is a principal, then the principal could be charged with the principal offense. Okay?
Oh, okay.
So nothing is wrong, especially that the adult is the one who is coercing the child to commit the offense. It may well be that the DPP could find that as an accessory before the fact, they could in fact be charged as a part of the offense itself. Okay, Carencia?
Okay, thank you, Minister.
Thanks. I would like, therefore, to ask members for their final comments, before we wrap up. I would start out by thanking the Secretary, who has done a fantastic job in preparing all these minutes, almost verbatim, and they were quite comprehensive, and for putting the support together, for the Attorney General Chambers, for the guidance that the Solicitor General, Mr. Foreman, and Ms. Sada gave us as we went along, to the CPC who worked overtime. You and your staff and your intern CPC, you continue to do yeoman service in drafting these legislation, notwithstanding the idiosyncrasies of the legislators who have so many twists and turns that you and your colleagues have to put up with. To the law reform, to the Ministry of Education legal team who guided the Minister of Education, to MOJ, Mr. Paul Bailey, who is online, but I am sure Chantal will convey and he will know how much I depend on them to assist me in making sure that I don't make too many wrong decisions. I still make some wrong decisions, some wrong comments, but they guide me along. But to thank colleagues, but most importantly, to thank the presenters. We had a number of presentations from various civil society groups, from UNICEF, from the Office of the Director of Public Prosecution, from the Bar Association, the Office of the Children's Advocate, thanks to the Children's Advocate, Dan Harrison Gordon, the United Nations Children's Fund, the Faculty of Law, Jamaicans for Justice, the Office of the Public Defender, and even if I don't call everyone, to thank you for your presentation. I would like all of these groups to know that the committee members were influenced significantly from their presentations, and I can assure you that you guided us in making some of our recommendations. It was not, the bills themselves were not lengthy, but the amount of research that went in from the civil society groups and all the public presentations from the Office of the Public Defender and the DPP, they gave us tremendous assistance, the Commission of Corrections and the Youth Juvenile Facility Corrections Officer who came and gave us some information. Colleagues, these bills were intended to raise the penalties for murder, especially capital and non-capital. I'm aware that a lot of time we spend in relation to children. And we cannot ignore many of the presentations who felt that children should be given greater understanding, which we appreciated. But at the end of the day, we cannot ignore that murder, there's a victim. And there is not only a victim, but families who bear and suffer the loss of sometimes a child, sometimes an elderly, but always a loved one. And the penalty for murder must reflect not only the public interest and the sentiments that are felt by the public generally, but the disappointment, the pain, and the agony that families feel when they lose a loved one. It is in fact true that the loved one cannot be resurrected. But at the end of the day, families feel that if the offender is just given a tap on the wrist, that justice is not done. And therefore, it is important that the penalty reflect and emphasize the gravity of the offense of murder. And that is why, in all the discussions we have had, we have made it known that the penalty that is imposed and that the legislature is sending to the judiciary, that yes, we understand that there are other aims of punishment, such as rehabilitation, and in virtually all crimes, there are different circumstances that must be reflected in the sentence. But at the end of the day, for this egregious offense of murder, the signal should be sent to the society at large that anyone who commits murder must spend a long time in prison. And the reason they must spend a long time in prison, not because the long time will bring about rehabilitation, but it must send that signal to the society that person who takes life, any person who takes life, must not benefit in any way from a short sentence, but should serve a period in prison that reflect the gravity of the offense of murder. So that is what, colleagues, I would like this Joint Select Committee to be able to indicate to our colleagues in the lower and upper house. And when we debate it in Parliament, that is the message that we want to send to the society. We don't want any of these sentences to be imposed, so let's not have any murder. But we know that we will have some, unfortunately. And once they occur, these potential murderers, killers in our society must appreciate that the consequence will be severe. So those are my comments in closing this and asking for comments from other members. Since you're in chambers, Mr. Gill, you can make your comments, and then we'll ask other members online to make their final comments.
You know, Chair, this was an interesting opportunity to review these bills. And I've often said that, you know, the smallest of bills or the smallest proposed amendments can go far-reaching in terms of deliberations. And for these three bills, they went into intense deliberations. I appreciate the stakeholders who came and participated and made their comments, suggestions, and recommendations. We take note of the fact that there was essentially a high regard for the protection of children. And the one dealing with the Child Care and Protection Act was the one that was heavily emphasized during these deliberations. But I think the committee would have sent a clear signal to those who commit murder that there's a higher threshold in terms of the penalties that are going to be imposed. And you are quite right, Chairman, We would hope that there is going to be no murder. But if there is murder, there are going to be higher consequences. I, being part of this committee, appreciate the work done by the technical team and for even keeping us, binding us as committee members, notwithstanding the challenges that we would have faced. But it was a great experience, and I look forward to the deliberations in those other two places later on.
Thank you very much, Senator Gavin Gill. Who would like to begin? Carencia, Donovan, I know you're under the weather, but I wouldn't mind some final comments. Shireen, Charles?
Thank you, Minister.
Okay, go ahead, Carencia.
Yes, Minister, I fully identify with your comments, your sentiments just now, and I only want to add that I am guided by the statistics to the demographic in terms of fighting, in terms of those who are guilty of the heinous crimes. I think those within, 14 up to 27. I was looking at that particular statistics, and I was alarmed that that accounted for over 40%, right, of the murders. So I am one of the members who am strongly of the view that if we can have a 14, 15, 16-year-old or those who are children committing those heinous crimes, we have to take a serious decision. It is certainly nothing that we would want to happen. It gives us no joy, but we have to ascribe to a higher sense of commitment to our people, a sense of justice, a feeling we have to let our society know that we are not only just issuing platitudes, but as a government that is responsible, as a government that is responsive, we have a primary role to protect all our citizens. And I just want to reiterate that this government is taking the bold step, the bold moves to change the landscape, to change the situation as it pertains to crime and violence through the legislative means. Thank you, Chair.
Thank you very much, Member of Parliament Carencia Morrison. Minister Williams, you will go.
Yes, thank you, Mr. Chairman. Let me begin by thanking you for shepherding this bill through the Joint Select Committee. As Member Gale said earlier on, it was an intense exercise, even though on the surface this looked like a pretty straightforward, small amendment, but the implications of it are significant. I know it's particularly relevant to the Ministry of Education and Youth. We have the 14 to 17-year-olds. We have seen actual commission of murders among that age group, and we want to send a very strong signal to our children that this society will not tolerate our children committing murder, and if they do, here are some harsh penalties that they will face. At the same time, we understand as well that we have to have rehabilitation even while they are in institutions in order to help them to become better persons where they will be serving the punishment. I want to thank all the members of the committee for their time and effort and for the robust discussion. I know that Jamaicans looking on will see and have seen that we've taken this seriously. We've deliberated. We didn't just come and, in tutus, we were out of there. We really delved into the issues, asking for statistics, hearing from a wide cross-section of Jamaicans. And at the end of the day, I fully support the decision that will go to Parliament in terms of the sentencing of children in the age group 14 to 17 who commit murder. Thank you very much, Mr. Chairman.
Thank you very much, Minister Gabriel Williams. Thank you very much. Donovan, you want to go now? Or Shireen? Or Charles? Who?
Thank you very much.
Okay, Donovan.
Chairman. Well, I just want to say that the homicide rate in this country, it is reflective of a country at war, a civil war. We have had too many murders, and the public civil society is depending on government, parliamentarians to take the lead and to take action to indicate and demonstrate to the nation that we are serious about stemming this scourge. And so I am deeply honored to have participated in these deliberations and proceedings, and I look forward to the debates in the House and eventually a more peaceful Jamaica. Thank you very much, Chairman.
Thank you very much, MP Donovan Williams. Charles or Shireen?
Minister,
Charles?
I want to just put little to the comments that you made in respect to appreciation to all the persons who would have participated from civil society, the technical team. Jamaica, well, the residents, citizens of Jamaica have been looking at this particular Joint Select Committee in respect to how we are going to respond to what I regard as being the most heinous crime that you can have, which is murder. It is one that is final to the victim, because once that particular individual is murdered, no one will see that person again. They can only hold a memory. Murder, Minister, destroys families, tears apart families, and where there are children involved, it basically destroys them. They have many, many years that they have to exist in a society without the support of a parent. It destroys communities, it tears apart communities, and it ultimately gives brand Jamaica a very bad name. And as legislators, sometimes I'm challenged because I am also an attorney who practices at the private bar on the defense side, and persons ask me, how do I separate myself? When I say that I'm a legislator, I'm an attorney, but I do believe that once we give to the person who is so accused a fair hearing, a fair trial, meaning from the investigation process right through to the court process, and if at the end of the day then they are convicted for this offense, then they must serve the time. And I believe that the time that we have placed in the legislation is reflective of the majority of Jamaicans. And it is reflective of a society that abhors murder. And we have to send the signal that we will not in any way, Minister, condone this type of offense. During the Joint Select, I got the comments in relation to persons who participated that they were just looking at a killing, because you have different types of killings. This is murder of which we speak, which is a specific type of offense. And if there are other things that takes it down a step where it may be manslaughter, or the case may be, then the court will deal with that. But we have to send the signal. I think we did justice in this case, and the signal is there. It should be a deterrent. Person should not, unless they are prepared to pay the time, spend the time, do the crime. Thank you very much, Minister.
Wonderful. Thank you very much, Senator Sinclair. SG Marlene, you'd like to say something?
Yes, just to speak on behalf of Senator Golden Campbell, Chair, she was having microphone issues at
Okay.
the start. And in fact, she had been suggesting an amendment, but you actually had proposed that amendment to the minutes. She then wanted to have some concluding remarks, as with all the other members, but she had a family emergency, so she had to leave the meeting.
I
So I'm
understand.
just apologizing on her behalf.
Okay.
Thanks, Chair.
I know she would have liked, and I know other members who were unfortunately absent, but I know we're hoping that this is the conclusion of the Joint Select Committee, and the report will be presented to Parliament at the soonest possible time. But we hope that there will be a robust debate of all members of the House, because I believe, this bill should be one that we should have unity of purpose, not only in the lower house, but in the upper house. We may disagree on the penalty or the time to be served, but what we must be united in is that we must condemn all acts of murder once committed, and because Jamaica is facing a crisis of, heartlessness amongst far too many of our young people who believe that violence can solve problems. Violence solves nothing. It merely causes greater problems and continue that cycle of violence. So we hope that in the debate, the appropriate signal will be sent that all types of violence, whether domestic, gang, inter-party violence, all types of violence must be condemned, and we must do everything to deter and curb it. So I want to thank all the participants once again, and now call this meeting and the Joint Select Committee considering these three bills at an end. Thanks to everyone.